Last week, Texas signed into law the most convoluted anti-abortion bill ever. Instead of being enforced by the Texas government through criminal penalties, it's enforced by private citizens with the weapon of tort litigation. The citizens that are able to sue under this law aren't even necessarily citizens of Texas. It gives everyone on the planet the right to sue for civil damages if any woman in Texas has an abortion. To this, my advice to all women in Texas:
Fly, you fools!
Run away! Run away! Run away!
I think that the message to women is that they are not welcome in Texas. They are pawns to be used in political maneuverings. Let's have a chat. Hello and welcome. Thank you so much for joining me. When I first saw the news about the new Texas anti-abortion law, my first thought was, another anti-abortion law. I was going to pass on responding until I saw that there were some aspects of this law that are very unusual. So much so that I don't think anyone can fully predict how this law will go. Frankly, I don't see the courts upholding it, primarily because I doubt even the most anti-abortion judges want to be used as weapons in the abortion dilemma. The law is lengthy, so I'm just going to focus on a few parts. The revolutionary concept in this law is the enforcement. Lawmakers did this to do an end run around the preemptive lawsuits that usually follow the passage of anti-abortion legislation. Normally, anti-abortion bills are enforced through criminal penalties, which are prosecuted by the district attorney. So following passage of a bill, the ACLU or abortion providers sue the district attorney or other officials to block the law before it takes effect and infringes on the rights of women to get an abortion. This law attempts to preclude preemptive lawsuits by making it impossible to know who to sue, as enforcement comes not from state officials, but from private citizens and/or groups. Limitations on public enforcement. Notwithstanding Section 171.005 or any other law, the requirements of this subchapter shall be enforced exclusively through the private civil actions described in Section 171.208. No enforcement of this subchapter and no enforcement of Chapters 19 and 22 of the Penal Code in response to violations of this subchapter may be taken by this state, a political subdivision, a district or county attorney, or an executive or administrative officer or employee of this state or a political subdivision. Here's the kicker. It can be enforced by any private citizen or group on the planet, with only two exceptions. Civil liability for violation or aiding or abetting violation. A. Any person other than an officer or employee of the state or local government entity in this state may bring a civil action against any person who performs or induces an abortion in violation of this subchapter. The other exception we will get to later. Actually, it doesn't even limit enforcement to people on this planet. Any person can bring suit. They just need to establish that you are a person. I mentioned groups. They would have to sue as individuals, but they could still be coordinated by groups. But it gets much worse. You might have noticed the abetting violation in the heading of that last section. Yep, you can be sued not just for performing an abortion, but for abetting, described as knowingly engages in conduct that aids or abets the performance or inducement of an abortion, including paying for or reimbursing the costs of an abortion through insurance or otherwise, if the abortion is performed or induced in violation of this subchapter, regardless of whether the person knew or should have known that the abortion would be performed or induced in violation of this subchapter. This would make it illegal to provide medical insurance that covers abortion in Texas. What this will do to medical insurance contracts already in effect will be a nightmare. Abetting could include the receptionist that aids in doing paperwork or setting up the appointment. It could include someone who gives a woman a ride to a clinic, even if they don't know why she wants to go to the clinic. Watch out, Uber drivers. You can be sued if you take women to clinics. So if a woman calls for an Uber or a taxi for a ride to a clinic or hospital, the only way to be sure not to be sued is to refuse. The driver can't know the reason that the woman is going to the hospital and can be sued if she gets an abortion while she's there. So will taxis and Ubers now refuse service to women in Texas? Other groups vulnerable under this law, escorts that help women through protest areas, they can be sued. People making a donation to Planned Parenthood are vulnerable. This would be an extreme example, and I doubt a court would go along with it, but it could still affect every woman in Texas. Suppose you sell clothing to a woman, and she wears the clothing to get an abortion. Is that abetting an abortion? Most likely not. But if a retailer fears being sued under this law, I could see retailers refusing to sell women's clothing. Amazon and other online retailers might start refusing to sell women's clothing in Texas. How about food? Again, I could not see a court saying that selling food that was given to a woman following an abortion to aid in her recovery is abetting an abortion. But I could see opportunistic people looking to score the civil damages payout, suing grocers making this argument. Should grocers stop selling food to women? How about restaurants? It's foreseeable that someone could sue a restaurant claiming that they serve food to a woman recovering from an abortion. Might restaurants refuse to serve women for fear of lawsuits? This is why I say the loud and clear message of this bill is women are not welcome in Texas. The fear that this bill intends to instill in everyone that does anything for a woman is too great. I really think that all women in Texas should at least threaten to leave and see if the men actually want women in Texas, or do they just want political pawns that they can use to assert their dominance? Maybe the real agenda here is to turn Texas into a men-only, right-wing Christian nationalist state. Another law they passed sought to get all transgender people out of the state. Who's next? So what can people get from bringing such a lawsuit? Would it even be worth the bother? Yes, it would. If a claimant prevails in an action brought under this section, the court shall award an injunctive relief sufficient to prevent the defendant from violating this subchapter or engaging in acts that aid or abet violations of this subchapter. In other words, if your business is to provide abortions, the court can issue an injunction prohibiting you from performing any abortions that violate this law. A court could also rule that a taxi company or an Uber may not transport women to clinics for abortions. Also, and here is the bait, statutory damages in an amount not less than $10,000 for each abortion that the defendant performed or induced in violation of this subchapter, and for each abortion performed or induced in violation of this subchapter that the defendant aided or abetted, and costs and attorney's fees. So anyone who knows of someone who had an abortion in Texas in violation of this law can sue for $10,000 in statutory damages. They don't have to produce any evidence that they have personally been harmed in any way by this abortion. The damages are statutory, so the plaintiff need not prove any monetary loss to him, her, or themselves to collect the $10,000, plus attorney's fees, against every person they can find that might have aided or abetted in the abortion in some way. What a nightmare! Attorneys that think they have a reasonable chance of winning are encouraged to file suit, as the defendant has to pay their fees if they do. There is no cost to the client, who likely had no real interest in this suit in the first place. He's just hoping to make some money off women in Texas. If they lose, do they face any penalty? Nope. A court may not award costs or attorney's fees under the Texas Rule of Civil Procedure or any other adopted by the Supreme Court under Section 22004 to a defendant in an action brought under this section. If the plaintiff wins, the plaintiff takes all. If the defendant wins, the defendant is still out costs and attorney's fees. This provision puts the onus on anyone who is sued, even if they are complying with the law. Now, they did make a few limitations, like, notwithstanding subsection B, a court may not award relief under this section in response to a violation of subsection A1 or 2 if the defendant demonstrates that the defendant previously paid the full amount of statutory damages under subsection B2 in a previous action for that particular abortion performed or induced in violation of this subchapter, or for the particular conduct that aided or abetted an abortion performed or induced in violation of this subchapter. So, even though every person on the planet has the right to sue you if you aid in an abortion, you can only be sued once for each abortion that they can prove that you abetted in. There is a 4-year statute of limitations on the law, so you have to file suit within 4 years of when the abortion took place. Potential defendants are not limited to Texas. If I give money to Planned Parenthood and it is used to pay for an abortion in Texas, I am liable under this law even if I don't live in Texas. Furthermore, whether I know my donation will be used for an abortion or not is irrelevant. I am still liable. It's not just Planned Parenthood and abortion clinics whose funding will be in jeopardy. It's every hospital in Texas. I am in awe that the hospitals didn't have enough political clout to keep this from passing. Hospitals will be in an impossible predicament. Women still have the right to an abortion. The law even recognizes this in a section discussing undue burden defense, as the drafters clearly understood that no law that creates an undue burden on a woman's right to an abortion can stand as long as Roe v. Wade and Casey v. Planned Parenthood remain federal law. The section states a defendant is exempt when the defendant demonstrates that the relief sought by the claimant will impose an undue burden on that woman or that group of women seeking an abortion. A court may not find an undue burden under subsection B unless the defendant introduces evidence proving that an award of relief will prevent a woman or group of women from obtaining an abortion, or an award of relief will place a substantial obstacle in the path of a woman or group of women who are seeking an abortion. If a woman asks for an abortion, the hospital can't refuse without a medical reason, if this is a service that they provide. But they are open to lawsuits if they provide the service. The only option is to stop doing abortions or watch their liability insurance go through the roof. This was obviously the intent of the bill. The framing of this law clearly anticipates Roe and/or Casey being overturned, as it provides the affirmative defense under subsection B is not available if the United States Supreme Court overrules Roe v. Wade or Planned Parenthood v. Casey, regardless of whether the conduct on which the cause of action is based under Section 171.2a occurred before the Supreme Court overruled either of those decisions. So if a woman has an abortion, then Roe is overturned, then suit is brought, the Texas legislature says the affirmative defense is not available to the defendant. In effect, Texas has deemed the overturning of Roe or Casey, which has not happened, will apply retroactively in Texas. I wonder how the Supreme Court feels about the Texas legislature predetermining how to apply a decision they have not made. One article I read said protesters who speak out in favor of abortion could be sued under this law, as they would also be abetting in abortion. But this is not correct, as the writers foresaw that a First Amendment right of free speech would be more compelling, and thus they wrote in an exception for free speech. This section may not be construed to impose liability on any speech or conduct protected by the First Amendment of the United States Constitution. An argument could be made that a donation to Planned Parenthood or a hospital is free speech. Such an argument was recently upheld with regards to campaign contributions. I could easily see a court going either way on this one. It has not been argued before, to my knowledge. We still haven't discussed what the bill actually prohibits. It's being called the Fetal Heartbeat Law, and abortion, while still legal, anyone involved in providing it is subject to civil suit if the abortion is performed on a woman who is pregnant and the embryo or fetus has a fetal heartbeat, defined as cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. It defines unborn child as a human fetus or embryo in any stage of gestation from fertilization until birth. I'm not aware of any prior legislation defining an embryo as a child. This bill also sets the stage for policing of women's pregnancies. If the embryo is a child, can a court determine that it is a dependent child under dependency statutes and force the mother to undergo a plan to protect the child, as they would with a born child? This would be another nightmare, bringing the juvenile courts and the foster care system into the picture as well. As a juvenile advocate, I have had clients report incidents of pregnant women drinking alcohol to me. It is not illegal, but they think it is. For some reason, it is becoming commonplace for people to think that they have the right to tell pregnant women what they can and cannot do while they are pregnant. The law directs physicians to test for cardiac activity, and it is explicit in the types of tests that are acceptable before performing an abortion. There is an exception for medical emergency. The prohibited conduct: a physician may not knowingly perform or induce an abortion on a pregnant woman if the physician detected a fetal heartbeat for the unborn child as required by Section 171.203, or failed to perform a test to detect a fetal heartbeat. A physician does not violate this section if the physician performed a test for a fetal heartbeat as required by Section 171.203 and did not detect a fetal heartbeat. So in the case of a pregnancy where the embryo or fetus is non-viable and has no heartbeat, a doctor can legally remove the fetus from the mother. This prohibition is only against physicians, which the law defines as: physician means an individual licensed to practice medicine in this state, including a medical doctor and a doctor of osteopathic medicine. Not in the definition is a physician's assistant, a nurse practitioner, or a midwife. And of course, the law does not prohibit back alley abortions by unlicensed persons. This alone should be enough to strike down the law, as it prohibits licensed physicians from performing abortions, but it does not prohibit the same procedure by anyone who is unlicensed. Encouraging the practice of a medical procedure by unlicensed persons is not in anyone's best interests. So how did it escape the notice of the Texas legislature that it is encouraging back alley abortions? Or did it? Is the real purpose to put in jeopardy the life and health of women in Texas? And so again, my advice to women in Texas is: another important question is with regards to the sound heard from a 6-week-old embryo. Is this really a heartbeat? I checked an anatomy textbook that said a fetal heart is sufficiently developed at this stage to be able to beat. However, I also found more recent studies that call this heretofore accepted idea into question. According to MedicineNet, British researchers analyzed scans of the hearts of healthy fetuses in the womb and found that the heart has 4 clearly defined chambers in the 8th week of pregnancy, but does not have fully organized muscle tissue until the 20th week. This is much later than expected, according to the study published February 20th, 2021, in the Journal of Royal Society Interface Focus. Previous studies of early heartbeat development in humans have been largely based on other mammals, such as mice or pigs, as well as on adult hearts and samples from dead people. The data being collected by the University of Leeds-led team is being used to create a computerized simulation of fetal heart development. This will help improve understanding about normal heart development in the womb and could lead to new ways to detect and treat some fetal heart problems early in pregnancy, according to the researchers. So the purpose of this study has nothing to do with proving anything with regards to abortion. It is a purely independent study. Human fetuses have a regular heartbeat beginning at about 22 days of pregnancy, which is one reason the researchers were surprised to find that there is little organization of human heart cells until 20 weeks of pregnancy. Fetal hearts in other mammals, such as pigs, which we have been using as models, show such an organization even early in gestation, with a smooth change in cell orientation going through the heart wall. But what we actually found is that such organization is not detectable in the human fetus before 20 weeks. Dr. Eleftheria Pervolaraki, research fellow at the University of Leeds School of Biomedical Sciences, explained. So what a doctor is detecting in early pregnancy is not in fact a beating heart. It is a pulsating gestational heart sac. The heart does not have the muscle needed to actually beat until about 20 weeks, about the same time as the fetus becomes viable. The law defines fetal heartbeat as fetal heartbeat means cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. Does this pulsation even qualify as cardiac activity? Does the pulsation qualify as contraction? These are medical questions that are certain to come before the court when these lawsuits start to be filed. This has been signed into law, but it does not go into effect until September 1st. Until then, I'm sure there are many attorneys even now preparing to litigate both sides of these questions. The bill should be called the Full Employment for Texas Lawyers Bill. Incidentally, my license to practice law is in Texas. Maybe I should get into this one. But from Alabama, though, there's too much prejudice against women to actually go to Texas. When I first learned of the civil suit enforcement of this law, my first question was, how would anyone unrelated to the woman have standing? Standing is the legal term for having a legal interest in the case. If you get in a car accident, I can't sue for damages because I wasn't involved. Black's Law Dictionary says, standing to sue means that party has sufficient stake in an otherwise justicable controversy to obtain judicial resolution of the controversy. The Supreme Court in Sierra Club v. Morton, standing is satisfied if it can be said that the plaintiff has a legally protectable and tangible interest at stake in the litigation. I was not alone in this concern. According to the Texas Tribune, the bill was opposed by more than 300 Texas lawyers who said it undermined long-standing rules and tenets of the legal system, including that a person must be injured to sue. So what legal interest could anyone in, say, Delaware have in a case of a heretofore unknown woman to them in Texas having an abortion? The law gives us that. In its statement of purpose, the law says Texas has compelling interests from the outset of a woman's pregnancy in protecting the health of the woman and the life of the unborn child. and to make an informed choice about whether to continue her pregnancy, the pregnant woman has a compelling interest in knowing the likelihood of her unborn child surviving to full-term birth based on the presence of cardiac activity. So the state is claiming a compelling interest in all pregnancies within the state being carried to term, but they have delegated the enforcement of that interest to private people. I'm not certain that they can do that. While there are some law enforcement duties that have been privatized, such as bail bondsmen, private warrant servers, and so on, I found no information on a government turning over its interests to be enforced by private citizens through tort litigation. This appears to be a novel idea. Other articles on this law agree that this is a unique feature. In my opinion, not a very good one. Some journalists are saying that under this law, a rapist could sue his victim if she gets an abortion. There is an exclusion for rapists as plaintiffs under this law. This is the second exception to who can sue under this law that I alluded to earlier. Notwithstanding any other law, a civil action under this section may not be brought by a person who impregnated the patient through an act of rape, sexual assault, incest, or any other act prohibited by sections 211, 021, etc. The journalists mistakenly claim that the person must be convicted of rape for this section to apply. But since the suit is being brought in the civil courts and the statute doesn't mention conviction, the defendant need only provide evidence of the rape, incest, or assault, not a conviction. So if all of these abortion laws are being struck down by the courts, why does anyone bother with them? Because they are effective in accomplishing their goal. The goal is not the stated purpose. Texas doesn't give a rat's ass about human embryos. If they did, they would have abolished in vitro fertilization clinics, which destroy thousands of human embryos every year. There is no legal right to create embryos in these clinics, and there is no legal bar to outlawing them as there is with abortion. The intent is to intimidate doctors, nurses, clinics, and hospitals into refusing to provide abortion services. According to Moira Donegan of The Guardian, even without formal implementation, abortion bans accomplish a lot for the anti-choice movement. They frighten and confuse pregnant women, and they further stigmatize abortion. They prove useful messaging and fundraising tools for state Republican politicians. And they set up test cases for federal courts, allowing the anti-choice movement to workshop new legal theories and tactics for narrowing abortion access and harassing providers out of business. If left intact, the law would not only force Texas women to remain pregnant against their will, it would also empower any misogynist or anti-choice person to impose their bigotry on Texas residents through frivolous and harassing lawsuits. Hopefully, the courts will throw out the civil suit provision. Do the men in Texas have nothing better to do than to try to control pregnant women? Do they think that the only way that they can feel good about themselves is to make women their political pawns? If so, then the women of Texas should
Plumber, you fools!
live your life. Theria pervoloraki. Dr. Eleftheria